Hi, good afternoon, everyone. Welcome to Hammurabi and Solomon Partners and the India Strategy Group. We are here today to discuss the Social Security Code 2020. This is our sixth in the series of knowledge series that we started. We have with us a very distinguished panel today of speakers from different sectors, across sectors, to give their perspectives, views, and towards the end of the discussion, we'll try and come to some clarity with respect to what implications the code is likely to have on the industry, on practitioners like myself, and of course on lawmakers as well. What's the takeaway for them from the session, which we can supplement for future improvement going forward. We have with us today Mr. Jatin Jalundhwala. Jatin Bhai is the Joint President, Legal and Company Secretary at the Adani Group. We also have with us Ms. Deepika Chaudhry. Deepika is Executive Director Legal with Xerox India. And additionally, we have Mr. Deepak Sharma. Deepak is General Counsel with India, Bangladesh, and Nepal with G4S Corporate Services. And of course, we have Mr. Roshan Ramapuram. Roshan is the Head of Legal and Compliance with Adecco India. Welcome to all our distinguished speakers on the panel today. Let me try and straight go to the speakers and take their perspectives on the larger overall perspectives on the code. Starting with you, Jatin Bhai, may I request you to give an overview of the code? How do you see the code from where you stand from the industry perspective? Over to you.
Yeah, good afternoon. Thanks, Mr. Manoj. I welcome to all the panel speakers as well as the participants. And this is a very good session being a social security. In today's pandemic situation, I think this is very important from the unorganized people level. Let me tell you, the Ministry of Employment and Labor has introduced this code, that is Social Security Code, and the President gave the consent in September 2020. And as you all know, recently the regulations, that is rules related to the same, have been notified on 13th November or so. And I think they are open for the feedback from the industry and the public at large. Now, what is this Social Security Code? The code is nothing but recapping or replacing about 9 acts which are prevailing today as far as India is concerned. And those acts consist of Provident Fund Act, Maternity Benefit Act, then Compensation Act, and like Payment of Gratuity Act and such other acts. Now it is good part and welcome step from the government side that there are 9 particular acts which gives the social security to the workers, and there are some different provisions across. Now they have been clubbed into one code, that is Social Security Code 2020. As far as this code is concerned, the government has tried to put not only organized workers into the framework, but also the unorganized workers, gig workers, platform workers. As for all, by defining all these type of workers and try to secure themselves. In the code, the most important part is the definition of social security. What is this security? And the security which provides under this code is mainly the measures to protect this type of workers. What I have said, this type of workers means gig workers, unorganized workers, platform workers. And now how to protect them? By providing certain schemes towards them and trying to uplift themselves in the situations where they are having some emergency or they are having some exigency in the family. Like a bread earner is died, that is the worker who is a bread earner is died, then the social security code will provide some benefit to the remaining family. In case of ill health, in case of maternity, in case of partial disablement, all these are the things which are very important for the workers. In India, if you know, about 80% workers are getting 10,000 rupees or less per month, and therefore their security is very important. Looking to this government has introduced this code. Apart from this, there are so many provisions which have been made in this code, which I think later on when we discuss over, we will definitely discuss in detail. But one of the points for governing this, that is the governance purpose of this code, there are certain boards which have been formulated or which are likely to be formulated by the government for the purpose of regulating the code, like a national board. And that national board, what it will do, it will see it will see or monitor the schemes which have been proposed. Similarly, if it finds that there are requirement of some amendments to the schemes, then they can propose the amendment, and there will be some great vigilance as far as this code is concerned, and some at a national level some board is sitting to monitor and to regularize these particular schemes of the code. So this is very important. Apart from that, there are so many provisions which have been made in the code, like provident fund, then pension scheme, then as far as maternity benefit, all this we will cover at a later point of time. But what I want to say that this is a welcome step by the government, and definitely what this will help a secured worker in the company, or secured worker either at organized level or unorganized level, which will uplift the productivity at the national level, which we are talking about the nation building. And this particularly code, if it is implemented in a right spirit, then it will definitely build the nation with the security of the workers. I think initially I would like to say this about this code being introduced. Manojji, over to you again.
Thank you so much, Jatin. In fact, that is very uniquely put that in nation building, this code should not just be a brick; it should be a wall. Taking us forward. Let's examine this a little closely. Especially, I would want to come back at some point with the panel on the role of national board or similar bodies. We have had the DOT and TRAI, how things evolved. We have all seen, the turf for space. A similar experiment is being done in the data space as well. It is provided for a similar body to give an overview and suggest recommendation to iron out difficulties. And now we have the national board here as well. So we'll revisit this in the course of the discussion. I just thought I'll flag it and park it aside and have your views on that as we go along. Thank you so much, Jatin Bhai, for the overview. And may I now request Deepika to touch on the key highlights that what from her perception, what are the key highlights that we should be taking away from the code. Over to you, Deepika.
Sure, Manoj. Of course, there are quite a few of them, but I'll restrict my talk only to the ones which are more relevant for organizations and which are the ones where, we need to keep a closer look at. So, like Jatin Bhai said, that the most important aspect of the code is to expand its coverage to a wider population of workforce, right? Which of course includes unorganized gig workers as well as platform workers. However, future of work, I think, is changing rapidly. There is a paradigm shift there itself, and COVID has shown us that the format of work itself may change. And we have to be absolutely we have to adapt to that fairly quickly. So a social security net which caters to your job or your place of work alone is not a conclusive answer. It has to be such that it provides coverage to to a wider range of work population, which is what it intends to do. So that's, I think, like Jatin said, that it's a welcome change. It definitely is a welcome change, because this is what is the requirement of Social Security network, that it provides a wider coverage. So, and and also it also includes newer categories into the coverage. For example, besides, of course, the unorganized sector, even for the corporates, for example, fixed term employees, which was not there earlier, right? Organizations could easily hire people for fixed term, and they may or may not be covered. They may cover them or not cover them under Social Security net. Work from home, or is another category, and we've seen that during COVID how organizations have adapted to that fairly quickly. And in fact, IT was always a front runner in that area, where people worked from home all the time, and it was a given, it was a way of life. But a lot of sectors, it was a new thing for them. They had not they actually frowned upon it. And during COVID, I think I don't know if there's any industry which did not opt for work from home. So I think work from home will also become way of life. And also what will become way of life is that, you know, part-time employment or stuff like that, and even fixed-term employment. So I think the code covers at least these two categories for sure: fixed-term employment and work from home category. Uh, so which is again a welcome change. However, will it have an impact? Of course, it will have a financial impact for organizations, which is something organizations will have to be cognizant of. And the other thing is, I think the other thing which will have, and of course, Jatin also already talked about, ESI coverage, of course. ESI coverage now, it will expand to, unorganized sector, gig workers and platform workers, etc. And of course, the coverage is now pan-India, taking it to 740 districts all across India. And however, how it will pan out, what will be the implication is yet to be seen. I think with the schemes coming in force, etc., we will know what is the impact of that. And EPF, on the other hand, is again a major reform. Aadhaar-based registration is, of course, is going to be there, and it makes it more individualistic than organization-based. The additional categories that have been brought into the fold are, for example, self-employment and other categories, which will increase the coverage as far as Employee Provident Fund this thing is concerned. And obviously, all the organizations where with more than 20 employees, it'll be applicable to. And the fact that they have also increased the penalty under EPF to 10 times, from 10,000 to a lakh, there is obviously an intent to ensure that the employees get the benefits in a timely manner, so that making the penalty so stringent. The intent is obviously that employees and there is an intent of employee welfare in that, for sure. And then another important change or an extension is in the Gratuity Act, where it extends to fixed-term employees as well, in addition to permanent employees earlier. However, the distinction there is that for fixed-term employees, that they become entitled after 1 year, whereas permanent employees, the benefit can be received after they've completed 5 years. So on one hand, for the organization, it will create, of course, some sort of a financial burden, because obviously there's another category that is getting included. On the other side, I think there will be some level of disparity that at the employee level one can see, or people may start to question. For example, if there is a fixed-term employee and he gets benefit by working on the same project for 1 year, as against a permanent employee who's entitled to it only after having completed 5 years. So there could be a level of discontentment or disparity that may come into the forefront after implementation of this. And Another aspect I want to talk about is the new wage definition. So the new wage definition, with its inclusions and exclusions, now will have to, of course, they'll have an impact on provident fund. Calculation. So employers will have to reassess and restructure their provident fund contribution in light of these inclusions and exclusions. So that's the other change that will happen, which of course will put some logistics as well as may or may not be financial burden, but that is something again we'll have to keep a closer eye on. And also on the code, I think there is code also seeks to constitute certain bodies we've already talked about, and I think Manoj, you plan to cover it later in the talk. I think so. I think these are the major highlights that I wanted to talk about, which we need to keep a closer eye on in days to come. Thank you.
Thank you so much, Deepika. In fact, that was quite elaborate and quite a bit of the changes very lucidly explained. In fact, this whole expansion of the coverage to fixed term and work from home across different benefits on the social security side, I think that that's a very, very landmark change, and we'll also need to see how it lands, frankly, because there's a lot of devil still awaited in the
The
rules
detail.
and the details. So,
Right.
there would be all kinds of pulls and pressures,
Sure.
logically depending on financial implications. But the real beneficiary should get home. I guess that is the intention of the court, as Jatinji was highlighting, that uh, carrying everyone, the entire workforce, is the primary objective, and therefore it's a very landmark development from the nation building perspective. May now request Deepak to come in and share, particularly from the experience side and his outlook on these issues from the past. What do you see as the key changes? Already some of them have been touched at a schematic level, but in a very focused way, from the pre-code scenario to the post-code scenario. What do you see as major changes that we need to look out for? And of course, anything else that you want to touch on. Over to you, Deepak.
Thanks, Manoj, and good afternoon, everyone. I think because we all have seen the pre-code and post-code obviously will come in some time. But the way the government has set up the codes which we are talking about now, I think, in my view, it's a step, tiny though, in the right direction. Because I think the government is trying to give a pretty modern look to the current legislations. And also, I think somewhere the government is trying to promote the ease to do business as well within India. So I think these are the two primary constituents, basis which, the government has come up with different codes, and we are talking about Social Security Code now. So I think these are the two major constituents for the changes in the existing legislations. And I will primarily talk about three at this point of time, and obviously later in the discussion we'll talk about others as well. But the primary three changes which actually strengthens the view of the government to promote business and also to give the modern view to the existing legislation is: number one, we have talked about giving option of fixed term employment, and also gig workers, platform workers, aggregators. So I think this was the need of the hour, for the government to regulate the workers who are actually supporting the aggregators or the companies who are actually taking services from gig workers and platform workers. So I think that's the step in the right direction. But when it comes to the cost impact on the employers, I think that's something which we need to see in future. Because if you talk about making a corpus and contribution of 1 to 2% of the turnover, and not the profit but the turnover, so I think that's a huge task, when we all know all these aggregators are currently not making any profits. So I think we need to see how it would pan out in future. But I think it's a step in the right direction. Second, I would say, standardization or uniformity in the definitions, because earlier all these legislation used to have different, or I would say they currently do have different definition for the same term. But in the current code, I mean, I think they've more or less settled the definition which is applicable for all the codes, except obviously few changes here and there for PF and ESI and gratuity, but otherwise largely they've settled it. And I would primarily talk about wages here, because I think that's the most contentious issue which we had earlier, and that was from the PF perspective. And I think all the large corporates are still struggling to arrive at the right definition of wages, because the wages as per PF department it's absolutely different definition what would one would derive. So I think by settling that, I think they have actually done a lot of good to the corporates. So I think in future, I think my view is that I think this would be more or less settled now. I think wages would not be that contested issue moving forward. And I think the third aspect is the the limitation period. So I think that introduction of the limitation period for starting an inquiry or for recoveries, I think, I mean, I don't know about others, but I have seen inquiries happening for a period which is 20 years before, 30 years before. So I think having limited that to 5 years, so I think that was a need of the hour again. And I think by doing that, I think the government has given a lot of comfort to the corporates who are struggling with all these inquiries. So I think these are the three major improvements, I would say, I mean, in the current code, which I would say is the step in the right direction. But obviously there are other changes also, but these are the three major ones I would like to highlight here.
Well, that's very interestingly put. In fact, you started off mentioning it as a few tiny steps, and then, but these are definitely very landmark steps, as we can see. Tiny in the beginning, but I'm sure they have to take shape and have the scale implication that is intended in days and months to come. But yes, the key areas on, I think the cost implication is going to be a push and pull factor for all stakeholders, including the government. That's also one of the issues we have kept aside to discuss later on in the panel discussion with respect to how much of comfort the government is also likely to support and how much is the readiness and keenness and the capability to do it. And limitation, of course, is a major change, because from the red tape that we've been trying to come out of for more than a decade, we've been saying that we're moving much higher in the ease to do business index, especially in the last 6-7 years, but this was still remaining as one major roadblock in terms of compliance already ticked off by companies, but being an open book issue for departments and officers to kind of come back and hound even in the best of compliance level scenarios. So this is definitely a great improvement that is likely to come about. May I now request Roshan to, before we get into the Q&A session, may I request Roshan to come in and share your perspectives, Roshan, on the future outlook, on what you see about the code from your perspective.
Sure. Thank you, Manoj. Good afternoon, everyone. I think when I say what remains, I think everything remains. There's nothing, though we see a lot of changes have happened or will happen, I think that most of the things remain. And from an outlook perspective, I think, in my view, it's definitely a leap, from a transformation side. Online processing, electronic submissions, renewals to provide uniformity and avoid administrative hassles is a great step towards digitization in my view. This outlook essentially exhibits attention to enhanced transparency, ease of doing business, and increased accountability. While the code is drafted and implemented, keeping certain principles of universalization, integration of fragmented schemes, decentralization of administration, right-based and single-window approach, it has certainly increased subjectivity and has room for interpretation also. Policymakers have made it comprehensive. I mean, like all the panelists have mentioned, the scope has been expanded to include social security to all type of workers, which are gig, unorganized, and platform workers, right? They will be now eligible for disability coverage, maternity. So the expanded scope in order to provide security to a larger class of people is also a real warm welcome. Code has provided a wider definition for wages, like Deepak just mentioned. Specific exclusions with ceilings have been provided for discouraging inappropriate structuring of salaries. So I think this was an issue, and I think with the code, these aspects are a little reduced, or probably it's been nailed. Also, uniformity in determining wages for the purposes of social security is another highlight what the code has brought in. This has been all this has remained ambiguous until the Supreme Court had clarified in the Vivekanand Vidya Mandir case in 2019. Even though it was clarified right from Ridge Roof, but then I think it was finally closed with the decision in 2019. And standardization is also something which has made it more black and white than gray. Now there are a few reasons why I believe it is black and white than gray. I will speak about it going forward. Another important aspect which I see is the facilitating approach, right? Unlike the existing role of inspectors, the code provides for an enhanced role of inspector cum facilitator, which means the employers and employees can look for support and advice from the inspectors or the facilitators. Even before getting into a penalty kind of a setup, it's kind of not, it's beyond conciliation, but certainly yes, there is some advice that could be sought, right? And another important aspect is establishment of career centers. So when I say career centers, instead of employment, earlier we had the employment exchange under the Employment Exchange Act, right? So career centers, though it has the same requirements or objectives of employment exchange, it also is a great move with the government's belief that career counseling is the key activity to enable the aspiring youth, right? Employers are now reported, even earlier also under the Employment Exchange Act, they were supposed to report vacancies. But then the centers, as depicted in the code, will act as a bridge between the employer community and the employee community, but also will provide vocational guidance and career counseling. So that's also a very important move. So this is looked differently from investments from other organizations, I mean multinationals, as well as countries who are planning to have investment in India. So typically boiling down to the ease of business side of it, right? As I said, most of the provisions of the code are in sync with the current legislation. Clarity also has been undoubtedly brought in, like exclusion of gravity from wages, defining what constitutes core activity. But certain inclusions where I feel, I mean, at this moment, I think we are yet to have the draft rules finalized, so we will have to wait. But I strongly believe that this may go through a lot of iterations to reach a settled position. For example, the definition of employee within the Act or within the code excludes apprentice under the Apprenticeship Act only, right? Now, apprentices are onboarded under Apprenticeship Act as well as standing orders. What will happen to the apprentices hired under the Standing Orders Act? Under standing orders of a company, right? So these questions remain unanswered. So we may have to wait and see how things would change out. And we also know that as per the current EPF Act, PF scheme is also something which complements the Act. Now, there is provision for having multiple schemes within. We don't know what is going to come out from the scheme, because one of the aspects in the scheme, it says that there is a ceiling or 15,000, when where we can ensure that employees beyond 15,000, or we can cap the contribution ceiling towards 15,000. If such cap doesn't exist, and by reading the definition of wages under the code, it means that there is no ceiling, a lot of cost, lesser take home for employees, and I think that ultimately gets into a cost side of it. So even though it is in the best interest and of well-being and social development, it increases financial burden and obligations on both employers and employees. So another point which I thought would be is, how does the positions on recent judgments or the judgments that has been placed in the past coincide with the code? So one classic example is the Vivekananda Vidya Mandir matter, where it has been told that basic includes all that is universally paid to all employees, right? Now here under the code, when basic specifically means that anything that goes beyond 50%. So to reach that, so if even though there are certain elements that are uniformly paid across, to be considered as basic, the threshold has to be beyond 50% of what has been of the total gross. So I think there is a little bit of conflict. I'm sure this will come up again as discussions or probably matters. Another aspect is on the Aadhaar. So there is, the language of the code talks about a mandatory nature of Aadhaar. So what happens to the Puttaswamy judgment, right? I think these are most vulnerable points, aspects that could be challenged. While I clearly agree, and we see that this is a very clear step in the right direction from an ease of compliance and other aspects in principle, whether the current social security can strike the right balance is something we need to wait and watch. Certainly it will evolve over time, and it's here to stay. So we'll only be able to comment on the effectiveness of it over time. That's what a couple of cents that I want to add, Manoj.
Thank you so much, Roshan. In fact, before we go forward with the discussion, I'm sure all of us are having an eye on the chat box, because a lot of comments and queries are coming about, and some of them are kind of coming about as some of us have been sharing our views. I see a lot of queries around PF and ESI, 15%, 21,000, 15,000 limits, and its consequences on computation of wages, etc. So, Roshan, as we go along, I request you to give a pushback to the queries in the course of your discussions. You can any of us can just pick up the question and kind of go ahead and give a pushback and a response. We don't have to wait till the end, because if we speak along the way, I guess we are able to intertwine it with the discussion more easily and cohesively. For the next issue to discuss, I want to just throw around a pointer for views from everybody on the panel, and I want to take the cue from one of the comments in the chat box, whether the code is a old wine in a new bottle with certain tweaks. So essentially, in other words, is it just kind of combining the laws which Jatin bhai mentioned in the beginning, or is it trying to bring about a paradigm shift? Do we see some more long-term implications? What are those changes which you're looking at? Jatin bhai, let me start with you.
Yeah.
Do we see this as an old wine in a new bottle? You did mention that it kind of combines a lot of these laws to make it easy. Yes, it does. And even Deepak mentioned that uniformity in definitions, and therefore a lot of ambiguities may go. But is it still repackaging the whole stuff, or is it trying to bring it at par with social security norms, which are kind of accepted norms across jurisdictions, or is it to bring a huge change in India? What is it that is driving it in the sense? Do we see this as an absolutely new directional change? Over to you,
Yeah.
Jay.
Yeah, Manoj, actually, in a lighter way, old wine is definitely a good one to kick for. So I should not comment whether it is old wine in the new bottle or not. But clubbing together of all the acts, I think it's not only a clubbing together all the acts. The particular code has been designed keeping in mind what has happened in past and how to eliminate those loopholes, or therefore the code can become a more realistic and more implementable in the interest of the workers. To my understanding, this has been taken care by the government. Before going to the certain provisions already we have discussed, I must tell, and you all know in past what was happening. There were a lot of unions, Lal Vavta unions, and so many unions were there. And all these unions, there was a strike for number of months. Strike was going on, and the productions was cut off for 3 months, 5 months or so. And a lot of hue and cry were happening across. But nowadays, if you see in India, that is not the case. The reason behind it that the laws have been properly implemented, and to make it more implementable, this code has been introduced. Because the major objective of the code is how to enhance the output, the productivity. In fact, this particular code must provide for the productivity link insurance, productivity link, not insurance, sorry, incentive to the laborers. So this productivity is more important from the India's viewpoint of India's growth, GDP, inflation and everything, and as an economy. This social security code, which was prevailing in UK and other places long back, and now it has been introduced in India with a definite goal by the government. And all we have discussed, there are certain provisions in the code which gives a specification that how it is to be monitored, how it is to be implemented. Say, for example, one of the points is coverage is been widened. Now, previously we were saying workers means so and so. Now they are defining and classifying the workers. Gig workers, unorganized workers, platform workers, unorganized place of work. All this has been defined in the particular code. This is very important because this gives a recognition to a particular class of worker as far as the code gives to them. Apart from that, the word social security has been also defined, which clearly provides for the objective. What is the objective of the code? Because the objective is that a person who is working for an employer, he should be protected in case he is ill, he is not in a position to work, or he dies, that for his families can get something. In case of maternity, the woman can get a particular benefit. All this has been provided in a small social security, one definition. Separately, if you see the particular certain provisions like gratuity, let me tell example of only gratuity. There is, we all know, a common man can be 5 years मेरे को सर्विस खत्म करना है, I want a gratuity. पहले जब हम जूनियर थे तब सोच रहे थे 4 साल कहीं काम किया तो बोलते कि 1 साल और कर लो नहीं तो ग्रेजुएटी नहीं मिलेगा. No doubt I worked only in 2 organizations, one for 20 years and this for more than 15 years. But this was the people thought of. But nowadays in this particular code, what is mentioned? Fixed term employment. And in case of fixed term employment of 2 years or 3 years also, he may get the gratuity proportionately based on the 5 years criteria. Suppose in case of a death of a particular person, then also he may get a gratuity proportionately. So these are the points which are already covered in this particular code. Most important part, what I'm saying, I'm not going into deep of all the provisions, but what I feel personally, the national board which is going to be constituted for this particular social security scheme, I think it has to play a very, very vital role. Like if you see SEBI in India, as a regulatory body, playing a very vital role and important role across. और सब लोग बोलते हैं कि भी सेबी का ये आ गया तो what is it? It's a separate, I think, subject altogether. But that way, national board has to play a role about various schemes, the schemes, whether they are implementable, the schemes are implemented properly. If the schemes require some changes, so immediate changes to be suggested, monitoring how it has been implemented. If it is not properly implemented, the employers shall immediately get a notice, employers shall immediately be questioned. All this is required. And then I think the particular code will be much more implemented in a desired manner, a desired goal. Otherwise, it will not be in a position to achieve a desired goal. In previously, if you see that certain code were there in 2008 or so, 2008, it has been implemented. But after 12 years also, certain rules and regulations have not been introduced even till date. So it remains on paper. Then the social code also will remain in paper. So that's more important is that the provisions are there, but how it has been implemented, and the government will take into consideration the aspect of the implementation. Like Niti Aayog you see in India. Now today how Niti Aayog is working very nicely. Everyone is aware. If you have heard Amitabh Kant, he has on his tips all the informations and figures about the various economic about of the India. So similarly, this particular board and other state level boards also shall work in a strict way and like a watchdog towards this social security code. Then only it will give a better result and the desired result. This is what I want to say, Manojji.
Thank you so much. That's very encouraging to hear. And of course, that is what the intention is. Now that the issue of national board has also come on discussion, Deepika, over to you on, is it a old wine in a new bottle, or is it a paradigm shift overall? And of course, I want to throw it up. The experiences we've had on sector-specific boards or regulators, has not been very encouraging so far because of the relevant department and this new regulator trying to finalize their turf. It's almost like India and Pakistan and a permanent dispute on where does the border lie. So we have, of course, things have settled a lot now in the telecoms area and a lot of other sectors. It's still on, and I'm sure there'll be things will fall into place. But do we have that luxury of time? With the kind of outlook and the kind of outreach this particular code is expecting to have, can we afford another 10 years of, trying to have the board understand its boundaries and responsibilities, almost like a decade that it has taken in other sectors? Over to you, Deepika, on the overall wine versus paradigm shift, and of course, if you have what thoughts you have on this, what do we understand of this annual national board?
Right. So, Manoj, I think I'm a die-hard optimist. So I think and like what Jatin said, and we've been talking about the fact that what is the ultimate aim? The aim is welfare, labor welfare. Aim is to ensure that more and more people get benefited out of this, right? That is the aim. And I think the bottom line that this code has been able to achieve is that bring in more and more people into the ambit, right? Which is, of course, the unorganized sector. And so to that extent, I think it is poised to cater to future way of working or formats that I talked about earlier. So I think it will cater to some of those needs in times to come. Now, we also know that most of our labor legislation and acts are really archaic. They were enacted in the year 1920 to 1970 kind of thing. They are almost 100 years old. So obviously there is lots to be done, and those were relevant and were able to cater to those times. Obviously times have changed tremendously. We in maybe in 1920, 30, 40, we mostly had people workforce in the factories, as against today it's not only we moved to offices, we also have IT industry, we have the ways of working has changed tremendously. So I think to that extent, there is a big paradigm shift, and I think this code will be able to sort of cater to that. However, of course, we also know that there is lots to be done yet, because it's not an sort of subsuming almost 40 acts into one, or 23 or 29 acts into three itself was a Herculean task, and is a Herculean task, and rules are yet to be sort of formed up in the way that will be in the shape or form of something that we will be able to implement. So lots has to be done still, but I think it's a step in the right direction as far as I'm concerned, and I think that's one. And the other thing is that if labor welfare is at the heart of it, then just tweaking the law itself is not enough, right? And there are other initiatives that obviously government needs to take, like skilling people, and also creating jobs for people, because if they don't have the skill, and if they don't have the job, or if they have the job and not have the skill, having a welfare security welfare net is not going to help, because you're not in the job to be able to take benefit of that. So it's just not one aspect of it. There will be many things that will have to be done. So of course, in terms of timeline, you said it's a long way to go, but I think the beginning has happened. So I think that's where I'd like to leave it at.
Thanks a lot, Deepika. Over to you, Deepak. What do you make of this? Do you see the desired intent in the administration to let go of the powers to be that they've been having on the oversight and on the working and control on the entire labor and employment area, the various departments and the officialdom that we know of? One, that, and of course, do you see this, and therefore is this a paradigm shift, or do we continue with the same red tape that we have been experiencing all this while?
I think, I mean, I would term this as, I think, midway. I would not say it's a paradigm shift at this point of time. So I think it's just a midway, because I think the government is moving in the right direction. And as I explained earlier, I mean, recognizing the gig workers, platform workers, and all, and also uniformity which they bring in because of this code and all. I think it's a step in the right direction, but still I think there are I think few things which which is required to be done, because like if I go through the code and all, I think the coffers of the government still remain intact, because they want to have social security platform run at the expense of only the employers. So I think that is something which I would say that I think it has to be a collaborative effort, which the governments should bring in, and rather than putting everything on employer, then I think they should also think of doing something for the employees. And also I think I think we all have seen that they bring in fixed term employment, gig workers, and all. So, and my one point here is that I mean, we all always talk about these people who are not covered, but what about those people who are uncovered employees? For example, the ceiling is 10. So what about those nine employees who are not covered at all? Like in case one employer is employing only 9 people.
And that's
So,
a huge
and
number.
yeah, that's a huge, this is exactly I was trying to say, that like gig workers may not match that number at all. So, and you're keeping those numbers uncovered. I think the government should have done something about them. And I think that's, I would say, a slip in the current code. So yeah, so I think these are a couple of things which I would like to say that, yeah, I mean, it's just a midway. And I think, and even I mean, I totally agree that, the government cannot actually, just put something upside down. So they can't change the whole law at one go. So I think gradually, I think we'll reach there. But I think currently we're just the midway, and I think over the next few years, I think there will be a lot of improvement in these codes, and then I think we will reach where we want to reach.
Thanks a lot, Deepak. Roshan, over to you. Uh, what do you see of this? Is it a more collaborative regime going forward? Is it a midway, as Deepak mentioned, or is it something to fly on the productivity side, as Jatin bhai was mentioning, or just a step in the right direction, as
No,
Deepak?
I completely agree. I think it's a step in the right direction, Manoj, because see, as rightly mentioned by Deepak, you can't just flip things overnight, right? And there is a lot of learning. So let's take part three, that is the EPF Act. It was incorporated in 1952, right? So there is a lot of learning that we have gone through. There's a lot of during the course of all these enactments, which are quite old, and 40, 50 years old, there's a lot of learning that we have done, and a lot of things or positions have been established over time, which is in the best interest of the employees, and they're trying to strike the right balance between the two associated parties, right? So I think it's very well in the right direction. But I echo what Deepak mentioned.
I think we're having some difficulty there. We'll move on to some more finer
Sorry,
detail and come back to Roshan.
sorry. I
Yeah.
think I just missed
You're
for
back.
a
Yeah.
second. I'm back. Yeah. So so that's what I was I want to confirm. I mean, inform that it's midway, but it is a start. Now, so coverage, what we see initially, there was the unorganized sectors were not covered. They were not known what social security could be. Right now, the government has put a step forward to cover them. Like the other people now, probably the other nine members that Deepak was talking, probably in the course of time, they will also be under the safety net of social security. I think that's the aim, which is being started. So I think it is certainly an old wine, but it's a more matured wine rather.
Can you also share your thoughts on some other issues that Deepak raised, Roshan, particularly with respect to some finer details on criteria of availing some of these benefits? The length of service, the number of employees. Is it an improvement there, or is it retrograde? Are we leaving out more than actually including many more? Where do we stand on these eligibility positions?
Yeah, I think if you look at the schedule one, it very well talks about to which establishment, which kind of establishments it has this security code been extended. 10 members, 20 members, so on and so forth, right? What I also feel, I mean, length of services may or could be a discussion point when it comes to only the gratuity side of it when you're looking at it, because the FT is that there's a lot of confusion that may erupt during the course. One rightly mentioned by Deepika, it could put into a discrimination side, or some disparity around employees who are full-time employees and fixed term employees. So that probably the length of services probably needs to be looked into. But I think, as I said, this is only a start. Now there could be a lot of changes in terms of how best is it good for the society. I'm sure the government also will look at what is good for the employers, whether the capacity, I mean, looking at the capacity of the employers, whether they can do it, and how things. And I think, as I said, it's kind of a rippling effect also. There's a change which has already started. It has got both negative and positive effects. But at the end of the tunnel, we will certainly see that everything will be in the right place where it has to be.
Sure. So we are trying to understand today where we stand so that we can calibrate the way forward, even for the lawmakers and also for the industry concerned as to how do we carry our can till we get to that egalitarian, environment on social security, where all the right balances have been put into place. Having said that, Jatin bhai, I want to come back to you on uh, the uh, uh, the fund and corpus issues around in the court. As Deepak was mentioning, has too much been left at the doorstep of the employers? A lot of a lot more number of workers are sought to be brought in, and of course, therefore a lot more social security in terms of value terms, in actual money terms, has to be provided as coverage. But is it something too much pushed around at the doorstep of the employers?
Yeah, Manoj. Yeah, this is more of a clarity on the contribution on the corpus by the government.
Yes.
So let me tell you, the government is keen on paper as of now. We can say, okay, on certain issues, how to fund those schemes. The central government, what it says, what we are repeatedly saying, that gig workers, platform workers, unorganized workers, and for them, a particular or specific scheme will be launched by the government. And now, on these schemes, either the central government will fund itself, or there may be funding by the central and state government combined. Or otherwise, it may happen that the CSR activities, corporate social responsibility under the Companies Act. Now that also will be put under this umbrella, and the corporates may be allowed for such CSR activities by funding to such schemes. So in that case, the funding is, as of now, I think it's not clearly coming out. But the corpus has to be created by the government from the viewpoint of the upliftment of these unorganized workers. And that corpus has to be created by the government. On the other side, for the employer and employee, the government has given us specifications about the percentage which they have to contribute. Like as far as example, provident fund is there, that employer has to contribute 10% and similarly 10% by the employee. And in case of specific industries, they have said 12% from either side. Secondly, in the pension, as far as pension fund is concerned, it has been told 8.33% of the PF fund PF percentage has to be provided under the pension fund. So these particular things are provided as a percentage. Similarly, what should be the compensation payable to an employee in case of a death, in case of disablement, that is also provided into. Say, as for example, in particular death situation, the person may be getting 50% of the wages multiplied by some relevant factor. And the government, what they have done, previously there was a cap of 1,20,000 which has been withdrawn this time. Similarly, in case of disablement, permanent disablement, it has been provided that the 60% of the wages multiplied by the relevant factor will be the compensation payable to an employee. But previously, the 1,40,000 was a limit which has been also omitted. So there are certain provisions which have been made, giving the idea about what percentage a person will get. Similarly, as far as the gratuity fund or some fund is to be created, one of the major important amendments which have been brought into is previously they can have the insurance from the life insurance company only. But nowadays, henceforth, the corporates can approach to any other insurance company or other places for ensuring those particular gratuity fund requirement. So all this has been changed, but the very important point is how the corpus will be brought into by the central government or state government or jointly by both of them along with the employer is yet to be notified properly. What fund will be created and how far will be applicable to the unorganized workers. Because I am saying 85% of the workers in India are the unorganized workers. So whenever such fund is to be created, it has to be more calculative and with clear statistic in mind has to be created. Then only it will be fruitful. Otherwise, it will not serve the purpose. Today, if you see the person getting a pension in such type of contribution of 8.33% of 10% of so and so, then maybe 1,000 rupees he may get a pension. Then what is of that 1,000 rupees in today's world? So this calculation needs to be done for creating a corpus or for establishing a particular corpus. Manoj,
Well,
thank you.
well, thank you for explaining that so lucidly on the organized and unorganized sectors both. Deepak, just to bring you back to have your pushback on particularly on the unorganized sector side, we have a scenario where there's still some clarity to come whether the central government would carry the can or it would be a corpus of central and state government, which is, well, as debatable as can be, depending on dispensations. Because in most cases where there's a disconnect between the center and the state, ideology and worker interest may not be the driving factors on coming to a common platform on some things. And then, of course, the CSR, even if the CSR is allowed as a permitted expense to meet these kind of corpus requirements, it will be at the cost of something, because that CSR is going somewhere today. Either there are big Indian mega multinationals like, even for example, the Adani Group or Reliance or Coal India, or whether the government side or on the private side, they're undertaking major CSR activities, almost like running facilities and townships from these funds. So if this side of responsibility has to be met, it will definitely be at the cost of something which is being done today, right? Even if it is to give it to the prime minister to handle the pandemic situations, whatever it is, but the money has to get diverted from somewhere. So these are all things which have a lot of ifs and buts. So where are we? Is there too far ground to be covered on the unorganized side going forward?
I think it is. I mean, as I told you, I mean, I mean, at this point of time, what I can see is that there has to be a fund created, but how, who would fund it? So a lot of things are not clear. And since now, at least for next maybe 1 or 2 years, I mean, I think all the industries are struggling with COVID and all. So I think if I take that as an example, or I would take that as a situation. So I think we are still quite far away before we can actually finally see the final thing, like who would fund how much, whether it would be only central government or state government or both, or it would be aggregated. So all that kind of stuff. So I think uh, we need to wait and watch at this point of time, but looking at the current scenario, I don't think we are I mean the end is near, so I don't think it's happening in the near future.
Roshan, any thoughts on that before I reach out to Deepika for her thoughts on pulling down of the Employee Provident Fund organization? So any thoughts on the corpus issues, Roshan?
No, I kind of echo both Jatin and Deepak for that matter. So I think again, some clarity is certainly needed, which probably we will see. Maybe I didn't get a chance to read the entire rules probably, so I'm not in a position to comment on what has been specifically mentioned in terms of corpus and other aspects within here.
Sure. Deepika, are you there?
Yeah, I'm there. Just a minute.
Yes. So before we move on to a very interesting another issue on the criminalization of the Social Security Code or the penal provisions under the code. Before we get there, I wanted to touch on this issue of the code trying to dismantle and undo some of the existing structures like employee provident fund organization, etc. Is this a step in the right direction? Some specific thoughts from you on this?
So I think, I mean, we talked about earlier also that some of these acts are really archaic and they're very old, and they did cater to the needs of time then, and they were more relevant then. And I think with the times we have to change. And I think dismantling for for something which is better, which can cater to the current needs, I think it's a welcome step, and I think it should be done, because obviously something which was relevant 100 years back cannot be relevant no matter how well drafted it was then. And we have seen in the past, I mean, dealing with the act and the whole working of it. Sometimes it creates some sort of hurdles for employers to create more jobs because of this, or makes it difficult for employees to and get benefit, or they're so delayed that by the time they get it, it sort of loses its purpose. So obviously making it more robust, and and everything now is fast paced, right? So the benefits also have to flow in fast now, and then obviously something which is new and something which is more relevant, I think it would be something in the right direction. But however, having said that it needs to be done, and we know that it's being subsumed and into one act, and there is a lot of there are a whole lot of these state laws, and so the rationalization needs to be done and all of that. With that, I think many hoops still to be jumped, but I think again it's a step in the right direction for me.
Thanks a lot, Deepika. And I want to bring up one more important issue for inputs from everybody here. Is on, we have seen the Companies Act undergo sweeping changes on decriminalization, and therefore, trying to make life easier and more compliance friendly for the industry and the corporates. Because, wherever transparency and accountability already comes in as a part of the system, I guess the criminal intent also goes down, because there's that much more oversight already available with the regulators, or a national board, or a collaborative labor official system, where they are ready to give advance advice, or there's a provision for advance advice to be obtained from them. We've seen it come into play in the competition space for a very long time now. With all this background, the overall shift from towards decriminalization of the corporate liability, and also the Social Security Code itself having so much more push on transparency and accountability, as we were discussing. Is there much of a justification, or on the penal provisions under the code? Jatin, by starting with you, probably let's have your views.
Yeah, thank you, Manoj. Penal provisions on the code, which gives when the offense is committed, even it prescribed for the imprisonment of even 5 years or so. And in certain cases, it provides the person who is in default, the employer as well as officer in charge at that point of time, will be punishable with imprisonment or fine. And when there is a word or, that offense can be compounded also. So these are the provisions in the particular act. My thought process is decriminalization is really a good step, because criminalization, even in today's India's situation, court, if you see, it takes 10 years either to convict or accuse the person, acquit the person. It's not that maybe today some offense has been there and a criminal case has been filed and he will be jailed immediately. It will take number of years to prove. So that will not serve the purpose of the act. And what you have rightly said about the Companies Act decriminalization, when there is a transparency and governance, then definitely decriminalization is quite, I think, encouraging step. And what I understand in this particular code also, when there is a violation or when there is an offense is committed, instead of going toward criminalization, there should be some monetary penalty, and which may be contributed towards the funds to be created for unorganized workers or gig workers or so. So that will help definitely the implementation of the code. By punishing someone, it's not helping to the code. So that is my thought process, sir.
Correct, and more so, even the Companies Act has undergone a transformative change over the years, where compliance, the responsibility of compliance now rests largely with the board. So you have kind of dismantled those officer in default structures quite a bit, decriminalized a lot of offenses which are capable of compounding or monetary penalty, which could then be of advantage to some other desired sections. So that's something that is we see as still required to be done. Deepak, your thoughts on this?
And just to add here, sorry,
Yes, yes.
a small example. If you know, even today, whenever you are breaking the traffic rules, either someone is not wearing the helmet, someone is driving when there is a red signal, then what happens? If it is going towards the criminal side, which may prove later on, but on the very next day or third day, you will receive a memo at your home for paying 500 rupees a fine. Depending upon the offense, you have to pay 1,000 rupees as a fine. So that immediate action of the government on such offenses gives realization to the other side that henceforth I should not commit such offense, otherwise I have to pay immediately from my pocket this amount. So that immediate, I think, action for payment towards the penalty will be of helpful and more sensible as far as this code is concerned.
Correct. Instant corrective action is
Instant
what.
corrective action. Yeah.
That's right. So that, if you do a default, it's not
You
subjected
pay
to
immediately. You
legal
pay
procedure.
immediately. Without any argument, you have to pay. I cannot say to the traffic rules, I have not broken it, it was not red light, it was a green light. You have to pay. That's all.
Very well
Good.
said.
Yeah, thank you.
Deepak, over to you.
Sorry.
So on this, I mean, I have mixed views on this. Because as we all know, I mean, I think this social security is largely for the lower cadre of the employees, majorly, and it's for their welfare. And as we all know, I mean, I think largely that cadre of people is exploited by a lot of employers. So, decriminalization of that, in my view, is not the right step, at least at this stage, because I think now, since we have reformed, or like we are reforming the laws, and decriminalization of the offenses under the Act, I think at this point of time is not what I would say is the right move. What they could have done, I mean, they should have retained this criminalization piece there, and maybe the monetary limit, as Jatin bhai said, that monetary limit, the fine penalties, that they could have increased, but they should have retained the criminal aspect of the offenses, because I mean, I think now the government is reforming the laws, and I think it will take maybe few years, maybe 5 years or 10 years, for them to actually put this under a self-regulated mode. And because largely I think, since the law would be new, and I don't know till what time it would get settled. So I think till that time they should have retained the criminal aspect. And when it was a common view that, yeah, I mean, now since it was regulated fine, sorry, it is regulated fine, and now there are not much exploitation of the workers and all, then maybe that would have been the time where they would have decriminalized it. But doing this at this point of time, when there is rampant exploitation of the worker, and so I think it's not the right move. They should have increased the penalties and monetary fines more, but that criminalization should have been there.
Sure. So, as I can hear you, what I can understand is that we first enable this entire transparent and accountable regime to fall into place, and then that's the right point to, unplug the criminal or the penal provisions.
Right.
Fairly. Roshan, your thoughts on this?
Yeah, I mean, I think I completely agree, Manoj, because See, we also need to know the parties associated. Now, we know that earlier, we had people who were agreeing to or complying with what was required, at least to a larger extent. Now we are including a little bit of, since we are expanding the scope, the sectors, not only from an employment perspective, right? The employers are also a little more into an unorganized way of working. So decriminalizing at this moment, it may not be the right move. Once we have things all settled, probably that's when we can think about whether we need to decriminalize certain activities or offenses against certain activities to have it controlled. So having imprisonment, will also act as a deterrent for such people who don't understand. Okay, let me manage. Some people come with an attitude of managing aspects, right? So that can be curtailed by having this concept at the moment. Now, once it's more regulated, it is, we're talking about more getting into more digitized mode and so on and so forth, right? Once that things are in place, then maybe the country or the government can think about decriminalizing aspects or provisions from the code. That's my view. At this moment, it is appropriate and necessary.
Thanks a lot, Roshan. In fact, at Manage syndrome, in fact, last couple of years, especially last 6-7 years, I think the push has been to completely eliminate the management part of offenses and to have clarity. I guess we may have made some progress, but there's still some ground to cover there. Deepika, your thoughts on this before we move on to some questions from the participants?
Yeah, so you remember when we moved to some time back, we moved to self-attestation of documents, and before that it had to be differently done. But there was a time when we moved to that, and there was this whole thing of self accountability kind of a thing. So my vote would be that there should be monetary fines for sure. They should maybe increase the monetary fine, whereas the burden is on the organization that's against the individual. At best, an officer may have sort of delayed a certain payment, and that's also the reason some of the officers are not willing to get onto the boards, for example, a provident board, etc., because of this whole criminal aspect attached to it, right? And you remember also, legal metrology, where if you did miss something very small on the label, your MD would be issued a summon in some godforsaken village or a district in India, which was highly abused, I think. So I think I would say that you can achieve the same result by increasing the fines. And I think similar to company law, thought process where decriminalization is being sort of talked about, and I think it's the right way to go. And I think we have to move to more self-regulation or accountability regime than to be sort of with a stick every time that, okay, if you do this, this is what will happen to you. My vote would be to increase the fines and not put people behind bars or something like this. No.
Absolutely. I was waiting for that industry perspective to come in because the entire metrology and FDA experience that we have had of the last couple of years has been a nightmare for some of the good folks who are working under transparent mechanisms and completely open to the style of working. So because of that bunch of people who also need to be handled, as Deepak was mentioning, who should not make hay of this entire confusion. There's also a very significant set of section in the industry which is impacted. And where is the right balance? I guess what Jatin bhai mentioned, there has to be a mechanism for the good players to not be subjected to the rigors of a very difficult regime which is put into place, because it becomes an antithesis to ease to do business as well. If with all the trappings of transparency and control and reporting back to the board, because of one mistake of some manager or somebody officer down the chain, the board has to be exposed to jail. So I think that balance of convenience always needs to be valued, and the system should be able to cater to that, should be able to understand and be able to give a pushback and advantage to the good section of the industry. Um, we have a little short while more to go now. Maybe we can try and take some of the questions they've been pouring on the chat side. Can I start with Deepika, you particularly, since not that gender is not relevant to all of us, but I want to start this question with you and then take it to the others. I know there's a question posed by one of our participants here, which says that the code is intended to be gender neutral, and therefore there are provisions like creche and other things, to be provided. And at the same time, the draft rules have a threshold of at least 13 female employees. So are we really going that far, or are we just creating window dressing provisions and then putting these thresholds, which, as Deepak was mentioning, the 10 employee threshold example, a huge section of it gets left out and does not get the benefit. Over to you, Deepika.
So sorry, I didn't get the question. So are we saying that there should not be any gender-specific provisions catering to the specific needs of to a specific gender?
No, you got the question.
I'm sorry, I didn't get the question.
You got the question exactly wrong, actually.
Okay.
The question was that
I can maybe take that
you got the
question.
flip of the question. The question was that the code is intended to be gender neutral, which is rightly so. That's the way to go. And for why only this code? All laws have to go in that direction if they're not already there. But having said that, with the intention of being gender neutral, and for gender neutral purposes, they've provided some trappings around the facilities which are required so that our female colleagues are not at a disadvantage in terms of employment opportunities and growth. So therefore, creche and other similar measures. But then the threshold for meeting these compliances has been in the draft. The rules, I believe, they have been set at 30 female employees. So therefore, a huge section of organizations or setups who are 29 or less female employees, they are at the risk of getting excluded from this benefit. So is the code going far enough to achieve this? Your thoughts on this, and any corrective or changes, or how much should we give up pushback and fight for the rules to be corrected?
So no matter how hard I try, my perspective will be totally relevant or coming from my gender perspective. So let's hear. Deepak wanted to say something, so let's hear his thoughts before I say anything on this.
Deepak, over.
Yeah.
Roshan, over to you.
Yeah, so I think I don't know. I mean, the code from a maternity benefit perspective, it only talks about for the applicability of a or having a creche, more than 50 is what the code talks. I'm not too sure because on the draft rules, because I haven't read the draft rules in its entirety.
Let's take that as an assumption that there is a provision provided for these facilities and there's a threshold provided. Now, is the threshold realistic if it's a number like 30 or 50? I mean, is it something realistic in the Indian context?
No,
because we
yeah,
have
so we also need to know, no, because you see, this is also a cost to an organization, right? We also need to see if you say that you are a one employee company and you need to have a creche or need to facilitate a creche, how can it be possible? I mean, it's all about practicality also, right?
Right.
So I think that's how it has been brought in there. I don't see a reason there's a number, and it does not stop an organization. In case my organization wants to, you can do it. It cannot. But then at least this is what it says. At least 50 employees. It does not talk about female employees under the code. It says if your organization is 50 or more employees, then you need to ensure that you have a provision for creche within 500 meters. I mean, this was the earlier, even the code speaks about the same thing, but I'm not sure about the rules. The earlier rules did say that you need to have it within 500 meters, so on and so forth.
No, I'm putting a very straight question. There's a question from a participant, and let's give a benefit of doubt to the participant who may have taken the effort of reading the draft rule. And he or she has, Priyaman, so she has placed a certain number that the rules say that in case there are 30 female employees, only then you need to comply. So assuming that that's a correct proposition, on one hand, you're saying that it can't be an arbit thing, like even if you have one female employee or, you need to have a creche because it cannot be viable and cost and etc. Even may not be useful,
Right.
be used. So that's one end. The other end is the government is trying to put a certain level where are we in this? I mean, are we there? I just wanted to get a sense on that.
Yeah, I think as I said, we are there. I'm sure most of the organizations are trying to, even if there was a requirement posed by the government or not, certain organizations are already there stating that okay, we will do it, irrespective of whether there is a mandate or not, right? By this, I'm sure a lot of organizations who haven't even thought about it will come forward. Certainly,
I
that's
think
that's how I look at it. Yeah.
I'm going to take this now. So I
So,
think it's basically a question of practicality. I mean, I think if a larger the organization, they can house the crash in their own facility, or if it is, I think the number is share practical aspect of it. That okay, if you are a 50 plus organization, then the chances of you having a crash nearby is higher. Or some organization then pay the employees to sort of separately, and then avail the facility of a crash which is not close to the place of work, but maybe close to place of work, kind of a thing. And as far as the act being gender neutral, so my vote would be that it should not be linked to women, because crash is not just needed by women, also by men, because men are also fathers. So I think a father may also want to put his child into a crash because he's working, or vice versa. So it should be totally gender neutral to that extent. It should be linked to employees, if at all. And I think threshold itself, normally we've always said that, for example, in case of benefits, I think Jatin, no, not Jatin, I think Deepak talked about the fact that the threshold of 10, more than 10 will be entitled to benefit. Then what happens to the first 9, right? So some of these thresholds don't really work, because they completely sort of discount the whole the purpose of what we're trying to do. So I think threshold in any case doesn't work in any situation, right? So if something has to be provided, then it just should be universal. And that's the other thing which is about this code, that the only thing that it misses out is the universalization of the concepts. It should be what is applicable to one should be applicable to all, kind of a thing.
well, that's Deepak. You want to add to it?
Yeah, just a couple of points from my side. I mean, pardon me for my views on this, but a very very pragmatic view I have on this is, obviously, at least in India, I mean, the uh, generally the women take care of the kids. So that's what we talk about in India, and that is why the rules talk. I mean, the crash facility, they are actually relating it to the number of women employed in a company. So I think, in my view, that's a very very practical approach. Otherwise, if they would have linked it only with the employees, then it would be an additional cost, as Roshan said, on the company, when there would not be any women employee who would even avail it. So I think it's a very very practical approach, in my view, that they are linking it to the female. But obviously this ceiling of 30, 40, 50, 20, this is always debatable, because even if it's 5, then what about those 4? So that's absolutely debatable. But in my view, it's a practical approach if they've linked it to the female employee. And also now I think, in the new rules, they have actually given an option to have the shared crash as well. So I think it's the right move in my view. And absolutely, pardon me for my views on this. I mean, this is because I'm
Uh,
slightly
that,
talking male here.
absolutely
Sorry for
nothing to
that.
pardon each other. Absolutely.
Yeah.
In fact, that's why we are here to share thoughts, so that at a non-personal note, we are able to give a pushback wherever improvements are still required, either in the code itself, or the rules that are yet to come, and the schemes that are yet to be formulated. Jatin bhai, before we close the loop on this discussion, your specific pearls of wisdom on this. How are you addressing it? You are a big organization. I'm sure you have crossed this river long ago.
I think Roshan has said that I think the corporate or the employer, apart from the code or apart from the law, has to take care of the employee. It may be 30 workers or 30 plus or less than 30. But wherever it is required, if they take care, it is betterment for the organization. So these are the threshold limit which have been put into by the government with some calculation in mind. But it does not mean that it has to be implemented in a strict way. What rightly said is, suppose in Swap and Establishment Act, what they have now said, 10 or more workers are employed, then also the maternity benefit will be given. Now, what is about 9 workers? So now a closed door professional having 8 or 9 people with that employment, in that case, that particular professional can also have the rules and regulations and even some facilities for the workers and employees, which will be helpful to the particular organization and the professional. So these are the rules which have to be followed, but the liberalization of the rules can be possible by the employer themselves to make it more friendly with the workers and employees. That is possible.
No, correct. So you've rightly said. In fact, this is something like any other employment terms. The way I see it is the number is not relevant. What is relevant is the employer carrying the can of, the needs of the employees. That is one principle. So whatever the number is, it should be flexible for the employer and employee to come at one place. Secondly, for this number, which is like 5, then what happens to 4? If it's 10, what happens to 9? For the employers in that segment, I guess as long as there's a transparent disclosure mandatory that whether I have a CRIS facility or I don't have a CRIS facility, as long as that is clear out there, informed, even whichever gender it is, a father has to take care of a child or a mother has to take care of a child, they can take a call whether to go and join that organization or not. If you have a need, then you tick box, you only pick the organizations which have that. I think somewhere an approach like this could, and a mandatory disclosure for people who don't fall in that 30, 20 or 10 threshold, I think could bring the largest possible number of parents, if I can say that as a gender neutral term, within the fold. So I think with this we have there are a lot more questions actually, and I'm sure we can take it in some way, give a pushback individually to the participant, because we also need to close the discussion at some point. We are running out of time. In fact, we have run out of time already. Can I request the last words from each of you, and then we can close the discussion here. And of course, we'll be having more sessions for each of the different parts of the code going forward. So we can always reconvene and take the discussions forward. Your last word, Jatin bhai.
So, last word, as far as this particular session is concerned, what is the industry perspective or how the code will be implemented? So for that, we have to see 3-4 aspects, which even I have told in my previous question answer, that 85% of the workers are unorganized. More than 80% of the workers in India are getting less than 10,000 rupees per month as a salary. Thirdly, there are 100 million approximately are the migrant workers. All this requires that the social security for this type of workers have to be attended more seriously and sincerely. Now coming to the code itself. Code, I think, may be having 14 or 15 chapters or so. And the code would be having about 164 sections. But the code provides for unorganized workers only in 1 chapter and 6 sections, where India is having 85% unorganized workers. So this needs to be thought over, and while even giving while giving our recommendations or our suggestions or feedback for the rules which have been framed into, we can provide such feedback to the government that more required to be done on unorganized worker sector. Otherwise, the way unorganized code, which was of 2008, after 12 years also, some of the registrations and some things have still not been done. The same thing may be repeated, and what we were saying, old wine in the new bottle, it shall not happen like that. And therefore, that is to be much more taken care. That's only my conclusive thought, Manoj.
Very valuable thoughts, and of course, we will be giving a pushback on the rules as well, and we'll definitely incorporate these and reach out to you as well for more specific
Yeah.
inputs on rules as well. Deepika, your last words.
Yeah, so I think the very interesting, debate and conversation. I really enjoyed talking to all the panelists and yourself. The only one this thing I'd like to add is that here for for the organizations, because like you, I think during the day you also talked about the fact that the whole burden is of some of the new categories is coming on the corporates. So I think the government has to be cognizant of that also. Whilst it's a very good initiative and very welcome, but at the same time, it obviously carries some financial burden for organizations. They have to be cognizant of that, and they have to find ways to support organizations to be able to sort of carry that burden in a way that it becomes less burdensome for them.
Very interesting. In fact, that's a major pain point till the clarity comes about, especially on the unorganized sector side. Unless we see those alternative fund flows falling into place, I think there's much desire to be done. And of course, I'm sure the intention of the government is not to go in that direction to throw everything on the at the employer's doorstep. But then, we'll all need to keep giving a pushback on this till we reach there. Thanks a lot, Deepika. And Deepak, over to you. Your last words.
I think it's a nice session, Manoj, you have organized. So nice discussions, and really fully enjoyed the company of Deepika, Roshan, Jatin Bhai, and obviously myself. So I think it was a great session, and thanks for organizing it, organizing this. And finally, the boilerplate, which I always use in all my sessions which I attend. So basically, all the views which I have put forth here, I think these are all my personal views and do not represent my employer G4S views at all. So by this, I'm signing off. Thanks a lot for this opportunity, Manoj.
Thank you so much, Deepak. In fact, thanks you pointed this out because all five of us here are in individual capacities as lawyers, and in some way, as a firm, we kind of do a duopoly of working and giving pushbacks, and so that, of course, is a two hat that I am wearing personally. But of course, it goes without saying that all of us here together are in our individual capacities as lawyers of eminence who are capable of discussing some of the issues, and
Absolutely.
we can add value to the process. Roshan, over to you. Last words.
Well, I really want to thank yourself and all the panelists, Jatin Bhai, Deepika, Deepak. It was quite an engaging session. I think it is relevant and to the point what we are doing at this moment. I think as last words, I would just like to say that we need to, irrespective of what is there in the code, right? I think we need to agree and comply with it in spirit. Compliance will follow. I think it's in the betterment of or welfare of a larger society. I think we need to look at it in such way so that the organization, the country, gets into the mode of betterment. I think that's what we need to agree and comply with spirit. Let's not say that okay, the code has an imprisonment clause and therefore I'm doing. I think we need to understand. And as one side the government is trying to build, develop certain things. On the other side, we have to kind of agree in spirit and follow it.
Thanks a lot, Roshan. In fact, that's a very good note to end the discussion. In fact, it all boils down to our governance outlook internally and externally. We've had the Quota Committee report recently putting stakeholders at the very center point of corporate governance, and that's what you are essentially mentioning, that we have to look at it more as something which eases off the working of every stakeholder rather than just looking at our perspectives. Well, with this, thank you so much for joining us today. Each of our distinguished speakers, Jatin, Deepika, Deepak, Roshan, and also thank you to all the participants. We've had a large number of nearly 300 plus participants who've joined us, and they keep coming. And it's a large section of our colleagues on the in-house side, as well as our colleagues from overseas, from different law firms. We have been doing a lot of collaborative exercises like this. In fact, the next one we are doing a discussion on the 12th of December, which is on enforcement of emergency awards in India. And we'll be having Justice B.N. Shri Krishna, who incidentally was the architect of the last round of amendments we had on the arbitration side. We'll be having the ICC lead for this part of the world, Abhirav, on the panel, and a few other very key and eminent speakers to discuss some very crucial issues on enforcement of. We also will be having a lead arbitrator and an expert arbitration professional from Stockholm, one of our colleagues from a foreign law firm, and two other speakers, which are TBC, as we say, to be confirmed, but equally eminent. So looking forward to catching you then, and of course, to further discussions on the Social Security Code, going forward in the coming months. Thank you so much for joining us again.
Thank you
Thank
so
you,
much.
Manoj.
Thank
Thank
you.
you. Thanks to all.
Thank
Thank you very much.
Thank you,
And
everybody. Bye.
Thank you so
apologies
much.
if we were not able to, respond to all the questions on site. Thank you.
Thank you.